SJC-12148, Office of Bar Counsel, and another v. Ariel J. Strauss.
Before we start, let me apologize for my bandages. Reports that the court has grown more aggressive with the entry of the new justices are greatly exaggerated. It can be attributed only to getting some skin cancer removed, so it's not a big deal, but I know it doesn't. It makes me look like I'm the spirit of 76, so but ignore it as best you can, and we will carry on. So please proceed. Mr. Pritchard.
May it please the Court, Terrence Pritchard for the Office of Bar Counsel. Bar Counsel asks that the Court adopt the facts and recommendations of the hearing committee and affirmed by the Board of Bar Overseers and impose an indefinite suspension with credit for time served. I'm splitting time today with Attorney Wolf from the Board, and therefore I intend to address the issues of the burden of proof, the sanction, and the surprise. Attorney Wolf will address other issues. The single justice erred in this case when she held that the burden of proof was improperly shifted, where the respondent had admitted to all of the facts in his answer that supported all of the counts in the petition for discipline. And in fact, when it came time for the hearing, the only issue that was undecided was the respondent's defense. It is the respondent's burden to prove his defense by a preponderance of the evidence. In the answer to the petition for discipline, the respondent admitted that he deposited funds into his IOLTA account for a client, Else Knight, on December 20th, 2012. He admitted in his answer that he wrote a check from that account on January 2nd, 2013, at the direction of his father to pay one of his father's bills, and he knew when he wrote that check that it was Else Knight's money in the IOLTA account that was going to support that check.
So the key really was the issue of whether there was a deprivation or not.
He also admitted in his answer that he paid the client, Ms. Knight, her funds in March 2013.
Well, I understand, and I know you'll get into the subsidiary findings, and I think you're going to suggest that the records are consistent with the board and the bar's position that there was a credibility finding that the money was never, cash was never segregated. But right now, as I understand it, you're talking about whether the opening statement shifted the burden of proof, and you're talking about, it's first of all credibility issues, and secondly it sounded like it was more of an affirmative defense. But my question, to go to my question is this: what wasn't the issue that was really being focused on was whether or not there was a deprivation from Ms. Knight?
I believe that was a major issue in the case, whether or not there was a deprivation from Ms. Knight.
And so then how does this burden of proof argument play into that, if that's the core issue?
Well, the rules of professional conduct require an attorney who collects money on behalf of a client to pay that client their funds as soon as possible. These funds were received December 20th. The client should have been paid as soon as possible after December 20th. The respondent paid the client in March, months later. So, in fact, his answer admitted that he did not pay her the funds when he should have paid her the funds.
I'm not doing a good job with my question. So I understand all that, and I know you're going to get to that. I'm on your argument about the burden of proof. So my question is, I understand that he admitted to that conduct, and even if you had the cash in the drawer with it in an envelope, which I know you say is inconsistent with the hearing committee's findings, but even if that were the case, that's still a violation. But I'm trying to understand your argument about the burden of proof. If the issue is the core issue, I know there's other issues, the core issue is whether or not there's a deprivation from Ms. Knight of the money. Why was the burden of proof on the respondent?
Your Honor, your question is entirely clear. I apologize. It's my answer that is unclear. The respondent admitted, I believe, in his answer that he deprived her of the funds because he admitted he didn't pay her until March, when the rules require that he should have paid her as soon as he got the funds. So I believe that part of his defense that he did not deprive her, it was his job to prove. I believe his answer admitted that he deprived her of those funds by not paying her until March.
Well, that's not really Mr. Strauss's position. His position is she gets back from the DR and she wants it in cash and it's an issue of a lien. And I know your position of that's not the focused on your burden of proof argument. So he's not getting up there and saying, okay, I deprived Ms. Knight of the funds.
I believe his answer, taken factually and compared to the rule, is an admission that he deprived her of the funds. I believe his theory after the fact was that she did not want the funds until she asked for them, which she has no obligation to do. His theory throughout the entire case, from this point of his answer, was that the only reason she needed cash is because she was going abroad, and I believe it was to Cape Verde, not the Dominican Republic, but that's a side issue. Was that she was going abroad and needed cash to go abroad. She left the country on December 20th. There was no need for her to receive cash after that time. After that time, he did not receive the settlement check in time to get her the cash before she left for the trip, which is why she requested the cash. So with that said, he has a responsibility to send her the funds as soon as he receives them, which he did not do. So I believe as to the deprivation issue, it was admitted in his answer, and there was no burden on bar counsel at that point to prove deprivation beyond the fact that he received the funds December 20th, misused the funds, and paid her in March, a few months later.
Can I move you to the standards that we have been applying since matter of Schopfer, if that's how it's pronounced? Intentional use of client's funds with no intent to permanently or temporarily deprive the client, and no actual deprivation should be punished by a term of suspension of appropriate length. But intentional use with intent to deprive or with actual deprivation should be disciplined by disbarment or indefinite suspension. Those are the standards in Schopfer that we've been applying for 20 years. Is it appropriate for there to be no distinction between permanent and temporary deprivation, or for there to be any distinction as to the length of the temporary deprivation, 2 days versus 2 weeks, 2 months, 2 years?
Your Honor, I don't believe that there is any distinction between the length of deprivation, nor should there be. I believe that the function of the rules of professional conduct is to protect the public and keep confidence in the bar. And the only bright line rule when it comes to misuse of funds is an intentional misuse of funds with deprivation equals a presumption of disbarment, and if you've paid restitution, an indefinite suspension. And the fact is, if you are a lawyer and you steal client funds and they are deprived, the penalty should be severe, and it is severe. And this court has consistently applied the fact that the amount of funds do not matter, the length of time of deprivation does not matter. I believe the Gonick case was a misuse of $1,600 for what was termed a de minimis period of deprivation, which I believe was only 13 days. That was an indefinite suspension because restitution had been paid. Also, I believe the Grossman matter was simply a misuse of $1,000, intentional and deprivation, and that was an indefinite suspension as well because restitution was paid. Misuse of funds case law has a lot of discretion as far as sanctions. Negligent misuse with or without deprivation, there's a lot of flexibility. Intentional misuse without deprivation, there's a lot of flexibility. Even intentional misuse of funds held for an expense or a retainer, there's more flexibility. The only bright line rule is if you intentionally misuse client funds and cause deprivation, you should be disbarred. And if
So
you've paid
can I
restitution.
just pick up on the chief's question, though? So should there be another category, which is intentional misuse of clients' funds with deprivation, but with absolutely no intention to permanently deprive and prompt restitution? Should that be a different category?
I don't believe it should be, Your Honor. I believe that our function of protecting the public and maintaining confidence in the bar, if you intentionally misuse client funds and deprive that client for any amount of time and for any amount of money, the sanction should be severe, and it is under Schoepfer and has been for a long time. In fact, I believe the discussion of the Schoepfer matter, if you look at the case law leading up to it, it sought to specifically eliminate this type of issue, where hearing committees were basically all over the map with their discipline and taking into account all sorts of other factors.
Right, I mean,
Counsel-
I'm sorry, go ahead.
So the standard of review we would apply to this particular point of the argument, are we looking at error of law, abuse of discretion? How should we look at that, what you say is a disparate result?
Well, I believe, and I believe Attorney Wolf's going to get into this a little bit more, so I don't want to take too much of his issue. But I believe that the board's findings, the hearing committee's findings, have always been subject to a wholly inconsistent standard. Not a de novo review by the single justice of the facts, but trusting the hearing committee in their credibility findings and applying a standard that unless the record is wholly inconsistent with those findings, that those findings stand. And I believe that's the case here, and I believe that's what should be applied here.
All right, thank you.
Thank you very much.
Mr. Wolf?
Good morning. May it please the court. My name is Jeffrey Wolf. I'm an assistant general counsel. I represent the Board of Bar Overseers. As Mr. Pritchard indicated, I'll be addressing the standard of review on appeal of findings and recommendations of the Board of Bar Overseers and the fact that the respondent received due process. SJC Rule 4:01, Section 8.6 provides that subsidiary facts found by the board shall be upheld if supported by substantial evidence upon consideration of the record. First, what this means is that on appeal, the court does not engage in de novo review of those subsidiary findings. As the court said in matter of Siegel, you review the determination of the board, I'm reading this because it's a direct quotation, only to determine whether it is supported by substantial evidence in the record. The scope of our review of inquiry is limited. While we review the entire record, as long as there is substantial evidence, we do not disturb the board's finding, even if we would have come to a different conclusion if considering the matter de novo. So that's the standard. Second, the board's recommendations and findings are entitled to great weight. Third, on the issue of substantial deference, the board's recommendation gets substantial deference, but by contrast, there is no special deference that's given to a single justice determination, and the cases to that effect are cited in our brief. What this means is that the single justice erred when she disregarded the well-established standard of review in discipline cases. The problem is that applying the wrong standard review then led the single justice to act as a de novo fact finder and make new facts that are either wrong or inconsistent. And then this in turn then led to a conclusion that the respondent did not receive due process.
Do you think another way to look at it is when Justice Duffley is looking at Ms. Knight's testimony, that it was really unclear whether she actually cared about the lien, and it was really difficult to discern whether or not there was any communication in January or February. And so I'm not sure that this is the case, but is it possible that it wasn't de novo review and what it was certain issues that really weren't clear from Ms. Knight's testimony?
I don't believe so, and I would also suggest that if one is going to dispute the findings of credibility or of witness made by the hearing committee, that had to do that, one has to have, as Mr. Pritchard pointed out, it has to be wholly inconsistent with other findings. Not wholly inconsistent with other evidence, but wholly inconsistent with other findings. And that it was not. And so the short answer would be no. One cannot, on review, challenge that. And I would also respectfully suggest that Ms. Knight's testimony, while not a matter of clarity, did indicate what really mattered, which was she didn't need cash when she got back from Cape Verde, and she wanted as much money as she could get as soon as possible. And as Mr. Pritchard pointed out, one does not wait for a client who is due her settlement in a personal injury case to say, when can I have my settlement now? The lawyer's supposed to pay it as soon as possible. The lawyer's supposed to pay it basically when the lawyer, when he's got good funds, and and pays himself, and give the client a distribution letter and all that other stuff that did not occur in this case. So the fact that she wanted cash and before she left, but didn't get the cash in time, at that point the money's due to her, even though she had wanted cash initially. So I hope I answered the question.
You did, thank you.
Okay. So I'll address three aspects, if I may, of the respondent's claim that he was denied due process. First, the so-called extraneous evidence, or as the single justice decision called it, an overwhelming volume of incompetent and irrelevant evidence. Second, I'll talk about the dicta and recommendation at the end of the hearing report. And third, the hearing committee's rejection of the credibility of the respondent and his father. On the first point of overwhelming volume of irrelevant and incompetent evidence, there wasn't any. In reality, what this boiled down to was two incorrect assertions. One was the anonymous tenant complaint. The single justice decision incorrectly stated that the hearing committee admitted an anonymous tenant complaint that was posted online and the respondent's father was asked about it. Neither of these happened. In fact, the anonymous tenant complaint was not even proffered at the time in pre-hearing motions when it was discussed, and certainly the father was not asked about it. Second, other questioning of the father. The decision wrongly said that, of course, bar counsel called Mr. Strauss the father. In reality, it was the respondent who listed him, subpoenaed him, and called him on direct. But when the father was called on direct, bar counsel didn't ask him about his business practices as a landlord and didn't ask him about his handling of the security deposits. There were only three questions to the respondent's father about security deposits, and those actually were by respondent's counsel, not by bar counsel. So there's also no questions, as the single justice decision said, about Anthony's, the father's, filing tax returns or whether the respondent has done so for him by himself. So in short, bar counsel did not ask the improper questions that were referred to in the single justice decision and this other non-existent evidence. And likewise, the hearing, it did not focus on the father's business practices. Remember, as Mr. Pritchard pointed out, the respondent admits that he's using Ms. Knight's money when, at his father's direction, he writes a check to pay his father's expenses. So you've got the misuse right there. The point of the affirmative defense is whether there's cash instead. And the hearing committee of the board said that's actually not really a defense because money's not fungible. But to the extent to which the respondent's trying to argue that it is, that he bore that burden. I just wanted to elaborate on an answer to your question, Justice Lowy.
On the issue of intent, I mean, I understand we owe you deference. The single justice owes deference on sort of fact-finding, but the determination whether it's an intentional deprivation, is that the same? Whether I mean, I understand the individual facts, whether he paid the money, when he paid it, but the issue of whether it's an intentional deprivation, is that different in any way? Is that a mixed question of fact and law, or is it a pure question of fact?
Well, that's an interesting one. Let me put it this way. There's no question about the intent because the respondent knew when he wrote the check from his IOLTA account to pay his father's bill that he was using Ms. Knight's money. So he's knowing that he's misusing it. So that's, I would say that really...
Is this when she's in Cape Verde? Or I can't remember the timing of all this at this point.
So what happened was she was going to Cape Verde. I believe her father was ill. So difficulty cashing a check in Cape Verde. She knows her settlement money's coming in. She asked the respondent to expedite the check from the insurance company. He says he does. Because there's a lien on some of the money, the insurance company cuts 2 checks, one payable to the lien holder and the other one for the bulk of for $558. The other check to the respondent and Ms. Knight. So that essentially is good funds. He deposits that money, but he doesn't get it until she leaves. So he does not have that settlement funds to give her in cash. All right, so meanwhile, she goes off to Cape Verde without her money, and he writes a check, the respondent writes a check from the IOLTA account using Ms. Knight's money, which is basically the only money in the IOLTA account with some small exception, to pay the father's bill. That's the misuse.
I understand the particulars. My concern relates, your brother drew a distinction between sort of intentional misuse and intentional deprivation, right? That an intentional deprivation automatically is an automatic suspension.
If I could, it's intentional misuse and resulting deprivation, not...
Right, okay.
Right. I mean, yes, one can intend to deprive, but, you know, the 2 parts of chauffeur, as I recall them, are intentional misuse and resulting deprivation. There's resulting deprivation. Did he know he was doing it? Yes. So can you say that he knows he's doing it? Is that intentional? I would suggest it is.
Yeah,
If one wants to.
It just seems like there's a very, you like the clarity in the law that an intentional misuse resulting in deprivation results in a suspension, right?
Yes,
Right.
disbarment or indefinite suspension.
And then there's this other category of misconduct that I'm not as familiar with this as you are, but there's this other category that you have much more flexibility. Then we get into length of time.
Yes, Your Honor. So if it's negligent misuse or if there's no deprivation,
Right.
then there's more flexibility. And I could elaborate on what those mean, but the short answer is those are the areas where there's more
So I
flexibility.
just want to make sure, and I'm sure I'm simple-minded and way behind my colleagues on this, but if you're negligently handling the client's funds with no intent to deprive them, we're in the time frame, right? Time frame penalty as opposed to this automatic suspension.
If I'm understanding the question, let me try to rephrase
No,
it.
go ahead.
If it's other than intentional misuse with resulting deprivation,
Right.
there's a lot more flexibility in each of the different categories.
Right.
Negligent misuse, with or without deprivation, each of those categories, you know, has
But
more
I keep
flexibility.
going back to this issue of whether this intentional is a mixed question of fact or it's a pure question of fact. But again, I don't want to belabor this. Mm-hmm.
If I can, I know we have these categories. Put them aside for a second. Tell me why it is a just result for the conduct that he did, assuming, and I'm prepared to assume for the purpose of this question, I'll hear from Mr. Maffey, intentional deprivation, which resulted in a 2-month temporary deprivation of funds from the client. Let's assume that, and I know that under chauffeur, that gets you disbarment or indefinite suspension. So, I mean, I know that once you get into those, once you fit into those pieces, that is what we have said is the presumptive sanction. Tell me why that is a just adjudication in this particular case.
All right. One has to look at this in a larger context, if I may, to make sense of this, which is the obligation to protect the public. And if you say that there's a sliding scale, then where do you draw the line? I think you call it the slippery slope. So if you want to say, oh, well, if it's over $1,000, then it's an indefinite suspension. If it's under $1,000, then it's not. You know, then what about $999? And the same reasoning can be applied to the time frame. If you say that a year warrants, a year of deprivation warrants an indefinite suspension, then what about 364 days? You know, I mean, how do you draw these lines? And none of them really address the core issue, which is protecting the public. The lawyers know If they misuse money and the client is deprived, they'll be disbarred or indefinitely suspended. That sends the message to protect the public. If you start saying, you know, your misuse isn't that bad, the problem is
Even for 5 minutes, if you deprive them for an hour, that same rule applies?
Well, the rule set, I can't remember the exact wording of Rule 1.15 in terms of how prompt, but it's not, you know, forthwith immediately. It's not that demanding.
A day.
Well, you know, how do I say this? I'd have to go back and look at the exact wording of Rule 1.15, which I respectfully say I don't commit to memory, in terms of how immediate the payment has to be. But it does not say immediately forthwith. So with that, I would say that if somebody says, well, the bank told me at 5 o'clock on Friday that I now have good funds, do they have to, you know, miss their train home to write the check that night? Maybe not. But, you know, I would say that when you are depriving somebody from something, you know, more than, you know, whatever the language of the rule is, then yes, it kicks in. But you know, when you've got months and you got thousands of dollars, as Mr. Pritchard pointed out, the Jody Grossman case was $1,000. The other case, I can't remember how many weeks it was, but I believe it was shorter than this case. So you got more money and more time.
I guess the issue is it's not a matter of whether or not there's no sanction. I mean, the lesser sanction in chauffeur is a suspension of appropriate length, so which is a pretty severe sanction for an attorney. So I guess we're speaking essentially, I mean, again, coming from Superior Court where I did a lot of sentencing, and not every sentence was a mandatory sentence. And I had to adjudicate issues in terms of severity of the particular crime and the circumstances and the criminal history, and would determine what the appropriate level is. And yes, was there differences among different judges? Yeah. And do we have now sentencing guidelines which seeks to limit that? Yeah. I guess the question is whether or not chauffeur is essentially a mandatory sentence, which may be arguably too harsh in some circumstances. And Mr. Maffei, I'm sure, will argue, is unfairly harsh here. So speak to that issue.
Your Honor, bar discipline is not about punishing a respondent. It's about protecting the public.
Well, okay, but from the point of view of the attorney, it certainly looks like they're being punished. I understand that, but well, you know it has a substantial consequence on the person's ability to earn a living. But yes, of course, there's no doubt that protecting the public is of paramount importance, accepted. But
and to that point, Your Honor, one of the other things that this court has said is that impact on the lawyer in bar discipline or the respondent's family is also of no consequence because the primary obligation is to protect the public.
Not true in Guidry, though. That's not necessarily true all the time. In Guidry, you had the mitigation with the family and all sorts of other strains. So it's not like it's absolutely no impact. We know from Guidry that there's some impact, some considerations. A heavy burden on the attorney against the presumption. I think that we know that from Chauffeur.
Yes, but
it's a heavy burden, but there can be mitigation.
There can be mitigation. Part of the problem, of course, is that Guidry was impounded, so we don't actually know what the circumstances were.
We have a sense that it's a family situation and a financial strain, though.
But what I'm saying is that that's what led to the misconduct. I apologize if I wasn't clear. What I'm saying is a similar related issue to Justice Gant's point about impact on the lawyer. So if the lawyer says, well, if you suspend me, then I can't earn a living and my family will suffer, the response is that doesn't matter. We're not concerned with the impact on you. We're concerned with the protection of the public. That was the point I was trying to make. I understand what you're saying about Guidry, but that goes to mitigation of the sanction. What I was saying is that, to Justice Gant's point, which is, what are we punishing the lawyer? And this court has said, no, we're concerned about protecting the public. There may be impact on the lawyer, whether the lawyer can't work as a lawyer and can't make money as a lawyer for the family, or the lawyer is suspended and can't represent clients. Either way, That's not the focus. The focus is protection of the public. And sending a clear, unequivocal message, which this court decided, as Mr. Pritchard pointed out, to resolve a lot of conflicting law prior to Chauffeur, and to set this bright line. So we have it. I would suggest if the court wants to consider revising that, one might choose it for another case and solicit amicus briefs. But to this narrow issue, we have a respondent who misused money, and the client was deprived, and that puts us in Chauffeur territory. As to the due process issue, which is actually what I was planning on talking about, our point is there was due process. There was no extraneous evidence. These things that were focused on did not occur. There was no objection to Bar Counsel's opening or closing, and the case law is pretty clear that a tribunal should expect vigorous advocacy, and the court expects that a tribunal, non-jury or other tribunal, can focus on what matters and expect vigorous advocacy and not get derailed by it. And as I said, there was no objection to the opening or the closing. The last point gets to the...
I think your time is up, so I'll give you a sentence or two to tell us what the last point is, and then we'll hear from Mr. Maffei.
The last point is when the hearing committee said in its dicta that on reinstatement, the panel should consider the possibility of undue influence, maintaining professional independent judgment. It was following on Justice Spina's decision in Connell a few months before, where he said that this was a lawyer who yielded to the pressure of a wealthy client to not do what she knew she should have done. And so they've got this in mind, and they're basically saying on reinstatement, the hearing panel should bear in mind that this is something to be considered. And this court in full bench decision in Nicholas Ellis and reinstating Ellis said Ellis can be reinstated, but he can't work for his family for 5 years. So the issue of not being unduly persuaded or yielding to influence either a powerful client or powerful family, it was not improper to simply say, on reinstatement, you should consider it. So that's the last point. So in closing, what we really say is that the single justice sanction was wrong. The findings were wrong that led to that sanction. It should be an indefinite suspension with obviously credit for time served on the shorter suspension that was ordered by the single justice.
All right, thank you.
Thank you.
Mr. Maffei, appreciate your patience.
May it please the court, my name is Tom Maffei, and I represent Ariel Strauss, who's here in the courtroom this morning. Preliminarily, let me just make one or two comments. In walking over, it occurred to me that the events that give rise to this appeal happened 5 years ago, almost this week. So when we talk about effect on the lawyer and that it's not about the effect on the lawyer, there's plenty of case law that takes into account the effect on the lawyer. And sometimes the court says, no prior discipline doesn't help, but it's a factor that's often mentioned. But when a lawyer is suspended for 6 months, as Mr. Strauss was, and has to tell his community that he was suspended, and tell every court he's ever appeared in that he's suspended, and it appears in, it's widely publicized, it is not no sanction to be suspended for 6 months. And that's what the fair, and I will argue to you, the right result is here.
Do we have to overturn our precedent to get there, though?
No, I don't think you do. Although I think that the chief just said the words mandatory sentence, I think the court should comment on the fact, as it has in the past, that the chauffeur standard is not mandatory. That word appears in several decisions. It's not mandatory. But it was addressing a need for consistency that pre-existed that, where we were all over the place. So is this going to open this up in a way that will return to inconsistent decision-making? I don't think so, because there have been exceptions. My brother mentioned the Grossman case that involved $1,500. That lawyer was indefinitely suspended, but there was a specific finding in that case that the lawyer actually phonied up a passbook and gave it to bar counsel to hide the fact that he was using the money. So I don't think you have to throw chauffeur to the wind. I think the word is out that lawyers who steal, and my brother, Mr. Pritchard, said stealing is bad for lawyers. We all agree with that. This is about as far from stealing as you can get. Now, courts, and particularly this court, is in the business of line drawing, and it's hard work. But to just say automatically indefinite suspension or disbarment when there's been either intent to deprive or actual deprivation in certain circumstances is not the right result.
But the case law doesn't say that. It says that the respondent, the attorney, has a heavy burden to show that the principles don't apply in that particular situation.
No question. And I think the burden was met here, and it was met for two reasons. And the two things that I wanted to say, and it's all in the papers, is on the one hand, the findings. I don't think Justice Duffley set aside any findings. I think she said that there was not substantial support for the key finding, and the key finding was about deprivation. She also went on to say, no matter what the facts were, no matter what the findings of the hearing committee were, you can't invoke the rule that you can never set aside findings of a hearing committee when the record was so poisoned by all this evidence about Anthony Strauss, the father. And if you read her 40-page decision, she took a lot of time to go through that record carefully, and she picked out, and I'll draw your attention to some of the examples, some of the most egregious attempts here. This was a relatively simple case about bookkeeping violations, count one, and misuse of Miss Knight's money. But there was a lot of testimony about rental deposits and currency reporting forms and tax filings. There was a lot more going on in this case than what was necessary to prove counts 1 and 2.
Well, you say that, but there was also a critical issue of credibility here between his version of events and what was ultimately determined to be a different version, and they found him, your client, not to be credible with regard to his explanation. So when you begin to deal with the issue of credibility, don't you have to know a fair amount about the background and circumstances?
Yes, Your Honor, you do. Here, the key finding was built on a almost non-existent foundation, and so it is well within the court's authority to set aside a finding because it's not based on substantial evidence.
Well, I mean, I'm going to stop you there. I mean, I read this in preparation for during the snow day, so it's a little bit stale, but my memory is that there's, I mean, not really a dispute that he owed money to his client, and there was money in the IOLTA account as part of that settlement, and he used that money to write a check to pay condo fees at the direction of his father.
Absolutely.
There's no justification for doing that, is there?
Well, this will take us into the whole issue of what was in the envelope, because I find it interesting that had the $4,000, and I'm not going to argue and try to set aside the finding about the fact that the $4,000 wasn't there, but for the moment, if the $4,000 was in the IOLTA account, and Mr. Strauss testified he didn't realize that you couldn't have whole cash. If it was in the account, he could have spent that $3,400 for the condominium fee for his father's building. Lawyers do that all the time. As long as the money's all commingled, money's fungible. It's not her $3,400 and his $4,000, it's all together. So the real problem was that the money wasn't in the account.
I thought you're not supposed to commingle those two. I'm confused by that point.
Well, IOLTA accounts, Your Honor, can be commingled or pooled accounts. When you read the decisions
from different
But
clients?
not with the attorney's money.
from the commingling that's prohibited is the attorney's money, but client money can be commingled with other client money. The word in chauffeur, where they talk about personal misuse, that's all about the lawyer who takes the money because this kid's tuition bill arrived and he's short of money, so he just takes the money and puts it in his operating account and pays the tuition bill.
That's premised on the fact that his father was his client?
Yes.
Which
yes.
gets you into all the stuff with regard to the father.
That's why I said, Your
Which
Honor,
is why it's a little bit hard for us to say, oh, that stuff was totally inconsequential, because if the core issue of credibility is whether his version of events is the true version or the Bar Counsel's version of the event is the true, then you need to dive into that stuff.
Well, on the issue of
and you lost on that as to the issue of credibility, and don't we have to accept their finding of credibility?
Yes, Your Honor. You can accept the finding that there was no $4,000 worth of cash and that the father wasn't a client. Although if you read Judge Duffley's decision closely and you look at Exhibit 23, which is a long list of transactions, it looks pretty clear to me that the father was a client. But put that aside. I'm not challenging that.
Isn't that precisely what they say we can't do? We can't basically be doing our own fact-finding, both as to issues of credibility, as opposed to accepting their...
And I'm not asking you to do that on that finding. I am asking you to...
So if you're not asking us to do that, then we're stuck, or you're stuck, with the finding that the father was not a client, that he paid the condo fees out of the IOLTA, and that he should never have done that, and that it resulted in some period of deprivation to the client. Those are the fact findings which were made.
The only finding I take issue with, which I believe is clearly wrong, is the deprivation point, not whether the father was a client or not. And if you'll indulge me, I want to read to you. The client testified, literally, it's 3 pages of the 2-day hearing, 3 pages. Just, if you listen, and this is what Judge Duffley focused on, if you listen to her language, she's not a Native American speaker. She's not sophisticated. So she was asked by the panel, not by the lawyers, when did you receive that money? Not exactly sure of the date. I know I think it was in March. What did you understand Mr. Strauss was doing in January and February then? He was trying to get me the money, but it was taking long, and I asked him again for the cash. That's when she returned from Cape Verde. And he said, okay, he was going to get me the cash and then wait for the rest of the money from CVS. So then on the critical finding of deprivation, she testified, when you returned from Cape Verde, was it your understanding that Mr. Strauss had collected part of the settlement money? Answer, yes. And this is after your trip to Cape Verde. Why didn't you collect that money from him immediately? Answer, I want to. What do you mean? I mean, he has it, so I said I can take it. Yes, I spoke to him in March, and that's when I got the money. Well, my question was there a delay between January and March? I don't really remember. Now, the entire indefinite suspension sanction rides or falls on the 7-week deprivation. When you read that testimony, it is not at all clear that she was home, calling, looking for her money. They only met twice, and both times Mr. Strauss drove to Brockton because she didn't have a car.
So can I just push back a little bit on that, if I could, please, Mr. Maffei, because I've obviously looked at that a number of times as well. It's not up to her. The money is there. The lien is not really a concern to Ms. Knight. And so we don't go by how strident she was in January and February about whether or not there was a deprivation. It's up to Mr. Strauss to get the money to her when it's available.
That's correct, Your Honor. You don't have to wait for the client to demand the money. On the other hand, we're talking 7 weeks. He's working in Brookline, she's in Brockton. Lawyers don't usually get the check on Monday and cut the check Tuesday or Wednesday. I realize 7 weeks is not a week, but when you put this all together, I get back to the comment about stealing. There was no intent here.
Well, then let me, if I could, give you a fastball down the middle. What's the best case for you that we should deviate from Sharpner?
I gotta think.
I thought it was a fast-growing mill.
There are lots of cases.
But not a negligence case.
No, every one of the cases cited in Bar Counsel's brief, London, Schofer, Bryan, Grossman, they all involve personal use. So all the cases, and in fact, Schofer's articulation of the standard actually uses the words personal use. So all those cases stand for the proposition that when there's personal use, and certainly a lot more money in most cases.
But isn't benefiting your father considered personal use?
In terms of the familial relationship, yes. And I assume and I accept the chief's comment that the panel found that the father wasn't a client. But if you look at it the other way, he didn't, when lawyers do this, and they should be punished severely, they pay their tuition bills, they pay their car payment, they pay their mortgage payment, they go out to dinner with their girlfriend. They don't pay a condo deposit that the father owns, the father happens to be in the real estate business. So again, there's a lot of line drawing here, and that's what makes tough cases. But on the question about whether this is fair, I say there was no personal use in the sense that he took the money. There was certainly no evidence of intent to deprive. The record is clear. He was calling the insurance company saying, we want the money before she leaves. That's not the actions of someone who's planning to steal her money. There was no concealment by the lawyer to the client. There was no loss of money. There's no complaint by the client. And this is a lawyer who was admitted in 2004. This happened in 2013. He's practicing part-time. He's got no history of prior discipline. It seems like, with respect to the line drawing problem, that to apply the mandatory sanction.
Well, it's not, as you correctly pointed out, it's not mandatory, it's presumptive. So the core issue is whether or not it should not be presumptive for your client.
But in my last couple of minutes, Your Honor, I think it's important, because there is case law that says that when the record is, as Judge Duffley carefully described it, I'm not sure what deference you should pay to the findings on credibility. I mean, it was an overarching problem. It wasn't as if, well, the jury said the light was red, and so the light's red. We're not going to challenge that. This was the key issue. My brother, Mr. Pritchard, started the case when he made his opening, said this is all about credibility. And then they proceeded to dump all over Mr. Strauss's father. If you look at there were two motions in limine filed, decided by the chair of the panel. And there's a laundry list of things in those two motions all about the bad deeds of the father. What's that got to do with the two issues that were before the hearing panel? Bookkeeping and violations of the IOLTA rules. You can't use cash. You have to put it in the bank account. You have to do the three-way reconciliation. And what did he do with Miss Knight's money? There was no reason to go into this whole story about the father and his license to the city of Boston. And he's, if they're using, as appears to be the case, the IOLTA account to return, to avoid the law on holding security deposits in a bank account, what does that got to do with anything? The testimony was he gave him $20,000. 16 of it clearly went into the IOLTA account because there's a record of that. And then there's the extra $4,000, and that's the one that the hearing committee said it never existed. But that was the extent of it. There was no need to go into all of this. And the only reason to go into it was to turn Ariel Strauss's credibility on its head. And if you read the hearing committee report, it's really quite a remarkable document. Starting with the footnotes, well, the word that comes to my mind is disdain. They had disdain for Mr. Strauss. And it was all about, we don't believe a word he says because he was doing all this bad stuff with his father. Well, maybe that was true, but that wasn't what was charged. And
Well,
he
but
paid his...
they also found him not to be credible with regard to his explanation, both that his father was a client and as to his explanation of the fact that he had the cash in hand when he took the money out of Iolta. To be blunt, this is not a case in which one looks at, they have a finding, assuming we accept those findings, that said that he intentionally went into the Iolta account, which resulted in a temporary deprivation. That puts him into the most serious category of chauffeur, and unless we revise that, it means that's the presumptive sanction. Then you have to demonstrate why the presumptive sanction would be fundamentally unfair, which is effectively pragmatically a burden that you need to do. And the problem that I've got with it is I've got a situation in which you're asking us to say the presumptive sanction is unfair in a context in which they said that he was not credible with the board. It would be an easier argument for you if the board said, we believe everything he has said, and it is what it is, and he came forward but that's not what we have. We've got a finding that he was not credible as to the two key issues in this case. So how do we find that we get around the presumptive sanction, given those other findings as to credibility?
Well, you need to accept the deprivation standard on the one hand. And that standard, as I say, you can set that aside, because if you read, that's the sum and substance, that's the entire testimony of Ms. Knight about the deprivation. It's not clear. So you could set that aside very easily. You could also say that given the extent of given 7 weeks of deprivation, that there is another category, as Justice Lowy said. It's not all or nothing. You could do that and leave the principle firmly in place. Lawyers who steal client money, lawyers who use money, actually intend to take their client's money and use it for their own purposes, or say they didn't really have that intent, but the effect of it was the client was out. Some of the cases, and there are, as you know, hundreds of these cases, many of them, all the ones cited by my brother, involve deprivations of 4 years, 3 years, 2 years. This was 7 weeks.
Oh, the Grossman deprivation was for how long? That's the $1,000 they keep
4
referencing.
years.
4 years, okay. So you want to create a short-term deprivation category, essentially, that you only intended to deprive them for, basically a week or two or a month or two while you sorted through your finances, and create a different category for that?
Or describe it as, if the evidence on deprivation is so unclear, we're not going to impose the mandatory sentence of indefinite suspension or disbarment. Again, I realize there will be very few cases that fall into this category, but of all the cases that I've read...
Really? Wouldn't this be something that would happen a lot? Lawyers don't intend to intentionally deprive. They're dealing with a financial pinch, and they're moving money around to avoid this problem. Isn't this something that would happen a lot? I mean, I understand your client may fit into a different category, but the idea of the hard-pressed lawyer who doesn't really intend to deprive for very long, just long enough to straighten out the mess, the pyramid scandal type of problem. You're putting money in one place and putting it taking it out to pay something else. You don't intend to screw people, but you end up shortly doing it because you're financially pressed.
I mean, there's always a risk that someone will figure out a way and try to avoid the sanction. But in cases where there's no... This case, I think, would be different if Ariel Strauss had taken the money and used it to go to
Isn't
Florida.
that sort of your strongest point? Before all this comes down, he's already given her the money.
I'm sorry, Your Honor.
Before all this happens, he drives to her house and gives her the money.
Yes, and he had only met her twice. And, it's It's no mitigation in the legal sense.
So
but the
what-
record
so
says
the
he was spending 80% of his time running a yoga shop. He was at that time a part-time lawyer.
But just to follow up on that, so the principle would be, if you're not forced into paying the money back, but do it voluntarily relatively quickly, you should be in the time suspension standard as opposed to the indefinite suspension standard? I'm not being rhetorical, I'm just asking a question.
No, I understand. Absolutely. In this case, again, I made the point about the lack of intent. You know, there's no evidence here. All the indications in this record show that he was hell-bent on getting her the money. That's why he was working with the insurance company. So again, unfortunately, it's the line drawing problem, and I know that the court doesn't want to draw too many lines, but the line about stealing, those cases are very clear. Lawyers should know, based on all the decisions that have come out of this court, that they ought to keep their hands off the client money. This case, given the whole constellation of facts, doesn't fit even closely into those cases when you look at the cases that I've read. Thank you, Your Honor.
Thank you.
Court, all rise. Hear ye, hear ye, hear ye. All persons have anything further to do, the Honorable Justices of the Supreme Judicial Court, Nelson Kent Boston, within and for the Commonwealth. At present apart, the sitting of this court is now adjourned. Court is adjourned, thank you. Please remain seated.